So today we've learned that a Muzaffarpur court has filed and ordered the lodging of an FIR against historian Ramachandra Guha, as well as several filmmakers such as Aparna Sen, Anurag Kashyap, Konkona Sen Sharma, and even Sham Benegal, for a letter which they had written to the Prime Minister, an open letter where they talked about the problems in the country caused by mob lynching and the sort of weaponization of the chant of Jai Shri Ram against minority communities. Now this letter had seen strong reactions with a counter letter written by certain other celebrities, and it turns out that 2 months ago, an advocate in Muzaffarpur in Bihar named Sudhir Ojha had filed a complaint with the court saying that, this was a case of sedition. Now what's happened is the court yesterday said that actually in fact there is a case for sedition made out in this complaint and is therefore asked for the lodging of an FIR. Now look, this is, to be clear here, this is not a stage where they've been convicted or there's even a charge sheet at this stage. But for the court to have said that look, there is grounds for the lodging of an FIR of sedition shows that they think there is some sort of prima facie case against these people. And that's where the problem comes in, because when it comes to sedition, the threshold for even reaching this stage is actually really high. Now we've obviously seen sedition cases filed against people for all sorts of statements and very innocuous things as well. But at the end of the day, the law is actually quite clear here. If we look at what the Supreme Court said back in 1962 in the Kedar Nath Case, they clearly said that just if a person is criticizing the government, even if it's very strong criticism, even if the words used are quite strong, these are not grounds for holding someone to be guilty of sedition. And from the Kedar Nath case, which in fact upheld and said that it is not an unconstitutional provision. However, they said it has to be following certain rules. And the rules was that basically any case where there is an incitement to public violence or something which disturbs the public order, in something very specifically which has that effect, only that can constitute sedition. Over the years, that's in fact been strengthened to require that it's not just sort of some violence sometime in the future. So I could be saying, I think we need a revolution sometime in India, maybe 10 years down the line, or where I don't specify that. That is not sedition. It's only when I'm inciting some imminent violence or public disorder that it becomes sedition. And what we see in the letter which was provided, that doesn't even satisfy any of these requirements. In those circumstances, it's very difficult to see how the court could have possibly accepted that there was any reason to accept Mr. Oja's complaint. And let's also look at the fact that Oja actually has previous over this kind of thing. He's filed tons of frivolous cases. In fact, according to his own estimate, over 500 or 600 cases. Tons of cases against celebrities, politicians, for all sorts of things which are not even actual crimes. He actually even filed a case in the Indian courts against Pakistan Prime Minister Imran Khan over his speech in the UNGA. So this is obviously not the kind of person whose complaints are very serious. So why did the Muzaffarpur court agree to this? Now that's obviously a big question. It's going to end up going to the Patna High Court, where they're going to file a quashing petition. Aparna Sen is confirmed to the Quint. Where this will end, however, is only when we stop allowing the law of sedition to be misused. That requires proper guidelines from the Supreme Court, from the government, from the high courts of each state. And that's something which hopefully will take place going forward.